Good evening, everybody, and welcome to the Robert J. Dole Institute of Politics, and happy Constitution Day to everyone as well. I'd like to ask you to please turn off your cell phones, pagers, and all other electronic devices that you'd also have to turn off in an airplane for the evening. There will be a question and answer period after the interview. If you have any questions, please raise your hands and a student worker will come and assist you. Please ask a question. Don't filibuster here at the Dole Institute. We're very against that. Introducing our panelists this evening is Associate Director for Civic Programming, Dr. Barbara Ballard.
Thank you, Julia. One of the things that you'll notice we'll have our students do welcoming for us this evening, because not only do we have a student advisory board, but we also want our students to become a lot more involved in what we do here at the University of Kansas, and that is to promote civic engagement, civility, and public service. I want to say welcome this evening to our program on constitutionalism across the pond. I would also just like to tell you that today is Constitution Day, and also known as Citizenship Day. And as a result of that, on your program, you have the preamble to the Constitution. And today at WESCO at 1 p.m., and for those of you who don't know about WESCO, it's the WESCO building on campus. We call it WESCO Beach. There's no water, but it's still a beach. And, you know, we do a combination. We had students today, and we have an agreement with the Department of Music as well to ring the campanile bells, and we have little bells, the same as you have this evening. And we have lots of our events. And so we're going to start with the front part of Constitution. And so, if you will, by looking on September the 17th, 1787, the U.S. Constitution was signed by 39 of the 55 founding fathers. In 2004, President George W. Bush signed a bill designating every September the 17th as Constitution Day. And we have had it since 2004 here, where we involve our students. And you'll also find, if you go to the football game on Saturday, that we will also have it on the large Jumbotron, where our Chancellor, our brand new Chancellor, Bernadette Gray-Little, will also be leading the preamble, and all the words will be on our giant screen. So if you will, for those of you who took bells, I'll have you ring them, and at the same time, we will all recite together our preamble to the Constitution in order Constitution Day. When we did it on WESCO, at 11 o'clock it was done on the West Coast. On the East Coast it was done at 2 p.m., and in the Midwest it was done at 1. So it was a nationwide program as well. So if you begin to ring, and we can, now let's see if we can ring and talk at the same time. All right? All right. If you want to, we can stop ringing. I don't think I trust it. Let's go. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. All right, let's all ring. We know we live by our Constitution. Thank you very much. You think that's pretty cool? Thank you. Good. Not at all. All right. I just want to mention some of our upcoming events, and those of you can see on the program, but I do want to just highlight them just briefly on the back. And I told you about the football game already, and it starts at 11. And upcoming events. For those of you who know about our study groups, you know that it's an opportunity for you to learn more in depth about a topic. And this semester, we have on Tuesday, our Republican fellow is Michael McKenna. And so he's on every Tuesday from 4 to 5:30 p.m. And on Wednesdays, we have Kay Barnes. And she has her study group from 4 to 5:30 as well. I also want to just bring to your attention next Tuesday, our 209 Muncie Journalism and Politics lecture. So if you're interested in that, please think about coming at 7:30 p.m. And our really big one is our Leadership Prize. Remember, we give them to outstanding people in public service. And on the 28th, we will have the pleasure of presenting to you Donna Shalala, who was the former Secretary of Health and Human Services under the Clinton administration, one of the longest serving secretaries, and she's now president of the University of Miami. And she will be here on September the 28th at 7:30. And I think we've had 6 recipients, and she's the first woman to receive the Leadership Prize. So I hope you will think about joining us at the Lead Center for this. And not only do I think she's more deserving, but I think you will enjoy what she has to say as well. We had a naturalization program here, and it was on Monday, September the 14th. And it's always during that week that we recognize and acknowledge and swear in our naturalized citizens. And Judge John Lundstrom is sitting in front of me, and he always presides with others at that ceremony. We had 99 brand new citizens who were sworn in here. And because they have so many guests, we can't have that many outside people. But to talk about 99 people from 36 different countries to be before us, where they're giving up their countries to become citizens of the United States. When we talk about being one of the greatest countries in the world, it's because we have so many people who can contribute and want to participate and be citizens in the United States. And that's an impressive program that we're happy to present and help co-sponsor in a way at the Dole Institute of Politics. And I would just like to acknowledge the judge in front of us because he does a wonderful job on that program. I also right now would like to thank Rick Levy before I do introductions, because in planning this program, I sent him an email and I say, Rick, what are we going to do this year? You know, Justice Six, I used to get him like, what are we going to do this year? Steve McAllister, what are we going to do? Because the School of Law assists us with our program as well. And he suggested that we invite Judge Brian Barker because he would be visiting on campus and he would just be wonderful for us to have as our program. And so I do want to thank Rick very much for making that suggestion and for the judge agreeing to come. And then I want to thank Jeff Weinberg because we were talking about it, and Jeff Weinberg has spent time in England. And you will find out that also the judge is from the University of Kansas. And Jeff made the contact and those arrangements. So often Jeff, thank you so very much. And raise your hands so people know who I'm talking about. And the judge, you too, so I don't want to think about leaving you out, okay? But one of those programs, you know, so many of our programs depends on other people helping us as well to get people here. And we're very successful in doing that. And I just want to thank those individuals for helping us make our programs that we can present to you as well. Now I would just like to tell you a little bit about our speakers this evening. And I will start with the judge. Judge Brian Barker, and I found out I had to ask, so you get educated all the time. QC, Queen's Counsel, is a British judge. And Barker was called to the bar from Gray's Inn in 1969 and was a leading criminal barrister, excelling as a prosecutor and a defender. He served as chairman of the Criminal Bar Association, and he was appointed Queen's Counsel in 1990 and was appointed as circuit judge at the Old Bailey in 2000. Judge Barker was appointed as the 79th holder of the post of Common Sergeants of London, the second most senior judge at the Old Bailey in 2005, succeeding Judge Peter Beaumont, who's also a Queen's Counsel. He has since presided over many trials, many high-profile trials. He is also married to Dom Ann Rafferty, who's also on Queen's Counsel, one of the United Kingdom's few female high court judges, and with whom he has 3 daughters. And we heard at dinner today that with 3 daughters and a judge in his household, he agrees with them. He lists his hobbies as golf and sheep rearing, and he is also a governor of Sir John Cass's Foundation, one of London's oldest and largest educational charities, which was founded in 1740. 1948. We also found that he also lives on a small farm. So in many ways, there are several things in common with a lot of our people here in Kansas. He also came on campus. He was very surprised at how much has changed since he was last here. I would like to go to Rick Levy, who's in the School of Law. He is a J.B. Smith Distinguished Professor of Constitutional Law here at the University of Kansas, and he joined the KU Law faculty in 1985. Having received his law degree from the University of Chicago Law School and having served as a clerk for Judge Richard Posner, U.S. Court of Appeals, the Seventh Circuit. In teaching and research, he is focused on public law, including constitutional law, administrative law, legislation, and government benefit programs. He was responsible for redrafting the University Senate rules and regulations relating to grievances and the university's promotion and tenure standards and procedures, and has served as chair of the university's judicial board and president of the faculty senate. We will have some opening comments from both, and then they will have a dialogue for us. And I think we'll find out a lot about what our Constitution is all about and how it relates and what the differences are to what they do in Great Britain as well. So I would say just sit back, relax, get your questions ready, and know that you will be entertained. You will definitely enjoy Judge Brian Barker and Rick Levy. And part of that is, how much do we know about our Constitution? How much do we know it works for us or does not work for us? And it is always in keeping with the goal that we have here at the University of Kansas and the Dole Institute of Politics to present to you, and you think for yourself how it works and ask your questions. Remember, civility is the word this evening. Thank you very much.
Well, I guess, is this working all right? Okay. I guess since it was my idea, I get to start off the conversation a little bit, but I'm going to try to keep it short because I think you're probably here to hear Brian rather than me as much as anything. What caused me to think about this as a good topic or a good opportunity for Constitution Day are two distinctive features of what I would say mark constitutionalism in the United States and distinguish it from constitutional systems in many other parts of the world, including most other Western democracies. The first feature of U.S. constitutionalism that stands out to me is the reverence, the particular reverence we have for the text of our Constitution. I was struck by the fact that we began this program by reading the preamble to the Constitution as if it was a liturgy at a religious service. The constitutional text in the United States has a certain sacred character to it in our way of thinking about the Constitution. It's different than the constitutional text of most other countries, which tend to be much longer, which are much more frequently changed. When they are changed, they don't add amendments to the end. They go back and change the text of the original document. So the peculiar or particular reverence we have for the text of the Constitution really stands out as significant from my perspective. The second feature of our constitutional system which stands out to me is the especially important role that the courts in the United States have had in giving meaning to the Constitution and causing it or contributing to its adaptability over time. Again, I think that we're not unique in having courts that declare acts of Congress unconstitutional or interpret our Constitution, but the distinctive and strong role that the courts play is in some ways unique in the United States. Now, what struck me about this in comparison to the United Kingdom, and I'll ask Brian to comment on this, is that there is no written constitution in the United Kingdom, and the courts in the United Kingdom do not have the same power to interpret the Constitution and declare acts of Parliament unconstitutional. And yet I think if you asked most people, they would say, what two countries or what other country is our constitutional tradition most related to? Where do we gain our constitutional traditions? We would probably point to England and the United Kingdom. So I think it's an interesting point of comparison, and that's part of what I hope to discuss with him in our conversation tonight. But I think he has some opening remarks and observations, and so I'll turn it over to him.
Thank you very much. Can you all hear me? Good. Well, can I say first of all how delighted I am to be here. I was last here in the autumn of 1968, and things have changed a little during those 40 years, and I've just been made hugely welcome. I am a graduate of in the graduate school. I took a master's degree in political science, graduated in 1968, and I've kept up my contact from that time, and I'm delighted to be back, and I'm very grateful to all those who gave me the opportunity to be here. I'm also very pleased to take part in this discussion, and may I share with you congratulations on Constitution Day, and I'm sorry I couldn't join word for word with you in reciting the preamble to the Constitution, but they are wonderful words. I'd just like to spend a couple of minutes, if I may, just outlining how I see the Constitution. And you see, I've got some notes, and I think it's only right that I got it as right as I could. But can I kick off with apologies to several of you who may have just heard this before in another talk I did yesterday, that the ideal audience, what's the ideal audience? Well, it was defined by one of your senators who sadly is now dead, but he was the vice president to Harry S. Truman. And he said the ideal audience is one that is educated, intelligent, and a little drunk. And it's for you to choose which of those two you are this evening. But can I just go back slightly, because really our constitutions come out of the same stream. They've divided at one stage, and it's interesting to see what the divide is, but they go back really into English history. And the major change was from Charles I, who some of you may recall was beheaded. Shortly after that, England had effectively a republic for a short time under a gentleman called Oliver Cromwell. That didn't really work out very well, and the people invited Charles II, who was in Scotland, to come back and be king again. But what Charles II did was to have a continual dispute with Parliament. Parliament as the representatives of the people. And as a result of that continuing dispute, the constitutional system as we know it really evolved from that time. And Thomas Fuller, who was the chaplain to Charles II shortly before he died, made it quite clear in his writings that the issue was, be ye never so high that the law is above you. In other words, the law is all important, not kings and not potentates, and you have that as a stream of consciousness through your constitution as well. Now, we do not have one document which tells us how power is divided and how power is exercised, unlike you. And our written constitution has developed and evolved really since the 13th century. And the official definition, according to our Halsbury's Laws of England, is that our constitution is based on the principle that no body or political party has a monopoly on wisdom, that state bodies should be democratically and legally accountable, and that they should promote good governance in the general interest rather than personal interest or the interests of a limited section of society. And that seems to me about as good a definition of what we're all trying to do as you could possibly have. And that is really how our principle of separation of powers has evolved. And our constitution, such as it is flexible and can be changed by our parliament. So Parliament, the representatives of the people, can enact anything they like, and that will change what we do. And if I can just spend 2 minutes just describing the system as we have it. Can you imagine a three-pillar system with the crown, the monarch on top of it? And the monarch is the head of state. She is the queen in Parliament. She is the head of the executive. and the government operates in her name. And the administration of justice is in the name of the Queen, and the judges, I'm one of Her Majesty's judges. And although her position is largely ceremonial, she does bind together all the powerful bodies in the country under a vow of loyalty. So all parts of those three pillars, which I'll come to in a moment, all make a vow of loyalty to the Crown. And the monarch really remains or retains a stabilising influence. Whilst governments come and go, the monarch is there to give that important foundation. The three pillars that I was talking about are the legislature, which are our lawmakers. Those are responsible for making our laws in our two houses, the House of Commons and the House of Lords, and they do swear an oath of allegiance to the Queen, but all acts of Parliament then receive a royal assent, and they can't go forward until they have it. The Queen has never refused to sign an act of Parliament, but that is the convention. The second pillar is the executive. Then the government of the day is formed from the winning powers, from the winning party, and our school kids have great difficulty in dividing the concept of the legislature on the one hand and the executive, the government, on the other. But it's the executive through the Prime Minister and the Cabinet who actually drive forward legislation and changes, and they are then assisted by ministers in the civil service. And under them, beneath them, are the armed forces, and that's something I'd like to come on to a little later on, in the sense they're further down the totem pole, unlike many countries where the armed forces take a really powerful part in the governance of the countries and can really take over, and have done quite often when they don't like what the elected body does. And the third pillar in this image is the judiciary. And the judiciary have an independence which has always been preserved. They're paid separately. They cannot be sacked unless for proper cause, and what they can't do is be lent on by the executive, and it's very important that that continues. But what the judiciary cannot do is to strike down legislation, and that is possibly the biggest single difference between the way in which our constitutions have evolved. What the judges do is to interpret the laws as passed by Parliament, and then there becomes a system of precedent based on the decisions that they have made. If the government don't like it, if the executive don't like it, then they'll pass another law and get it passed through Parliament, and then the judges will have to reassess and get on and take notice of the new law. And what there is, though, is a judicial review by judges of excesses of what government officials may do. And this is decided in our level of administrative courts, who are able to review things that aren't very popular one way or another. For example, zoning decisions or something that isn't done judicially. And the argument is that if it's not done openly and properly, then that can be reviewed by the judges. But they cannot strike down something as being unconstitutional. So that is really the way in which our country is governed. It's according to this constitution. It's called a constitution, although there is nothing written, and it's generally understood in this way. And whatever the shortcomings of it are, we are blessed, we would think, with a government under a rule of law, freedom under the law for our citizens, and a vigorous democracy. And we take it for granted that our Prime Minister and our ministers are regularly answerable in Parliament for what they've done, what their policy is, and what they intend to do. And that can't be said for many other countries. So I finish by saying this: our constitution may be an illusion, but it is an illusion that is accepted, and it is an illusion that seems to work.
Well, I guess, thank you very much first. That's a very helpful summary. I'd like to start with the question of whether you would characterize the Constitution of the UK as fundamental law. In the United States, we start with the premise in Marbury versus Madison that the reason why courts can declare acts of Congress unconstitutional is because the Constitution is a source of law and it's the superior law. So is the Constitution in the UK a source of law, and is it superior to other laws?
I don't think we regard it as a source of law. It is there as a guide. The fundamentals are there. If there are any changes, it's going to come through the will of the people, effectively through Parliament, through Parliament passing new acts and legislation. But it is not. It's not a sort of independent, self-supporting entity, I think, in the same way that the Constitution is in the United States. It's more of a sort of background wallpaper, if I can use that expression, than a somewhat more central concept, which I get the impression that the citizens here would regard the Constitution as.
Then does the Constitution figure into the political process to, for example, in Parliament, would opponents of a bill object to the bill on the grounds that it was inconsistent with the Constitution?
No, because there is no Constitution. They may object to it for political reasons, and to say, well, my constituents don't particularly want this particular act to go through, or this project, or whatever, and then there's a debate. But usually the government of the day will win because they have a majority, and in the end it's a majority vote. But nobody would say this is unconstitutional. You may have some commentators, whilst perhaps these matters are being debated. Some judges or lawyers, well, it wouldn't be judges, but it would be academic lawyers who may say we're not very happy about this prospect. There might be something about, locking everybody up for 7 days without charge, or something, for example, yes, which the government could pass if it wanted to, or for 3 months without charge. And so the academics would say, well, this is unconstitutional in the broad sense of the word, in the sense that this is not something which is fair, right, or acceptable under the rule of law in the broad sense. But in the end, Parliament is sovereign in that sense, and they can do what they like. The remedy is down the road when there is the next election, and there has to be an election every 5 years, and the remedy is for the people to say we're going to vote against the members of Parliament in each constituency, and hope that the characterisation, the colour of the government then changes.
So, just changing it from another tack, would you like the power, as a judge, to declare acts of Parliament unconstitutional?
Well, no, is the short answer.
Not a fair question, but what I'm curious about.
Yeah, that's an awesome responsibility. What the judges do is to remain the essence, and again I think there's the same essence in the United States, of the judiciary to be independent and upholders of the law, of the broad common law as it is, but to be able to interfere with really what is political business. The politicians are there, they're the elected representatives, that's their job. And I think it's a big step, really, for a judiciary or a Supreme Court to be able to say we don't like what the politicians have done.
Well, of course, we hope that our courts are not just saying we don't like what the politicians have done, although one sometimes suspects that influences the outcome. I suppose the power of judicial review goes to some extent hand in hand with the existence of a text that is authoritative and that one has recourse to.
It is generally judicial review is based on the premise that the decision has not been made in a judicial, open way, and proper reasons haven't been given. It's capricious for some way or another, and if that can be established, then they would say, no, this decision is not appropriate.
This decision by Parliament?
No, the decision by an official in the name of the government under some act or regulation.
So there is judicial review then of the government's compliance with statute, or the administrative compliance of a statute. If there were an authoritative constitutional text, would it make sense for there to be judicial review in the UK?
Well, we've chosen that route.
Of no authority.
Of no authority, which I would think gives quite a lot of flexibility, really. And it's just two ways of looking perhaps at the same thing. The problem we would see with the constitutional ability of the Supreme Court to strike down legislation that it thinks is unconstitutional is that who then are the judges and how are they then selected? And is there then a problem of political bias? Then they become far more analytical. Our judges are not subject to any form of exterior scrutiny. And that's an interesting point as to whether that is right and proper, and whether a judge can be tested on what their political beliefs are. None of our judges are political in the broad sense. If you're a judge, you have to renounce any political affiliation, and you're deemed to be independent of any party. You can vote, of course, but you're not allowed to promote any side or the other.
Well, we would certainly hope that's true of our judges. When a judge is appointed in the UK, does Parliament have any role in that appointment process? It's quite high profile these days with Justice Sotomayor and that appointment process. Are judges vetted by Parliament?
No, not at all. So and on the basis that would then mean that there is interference, in inverted commas, with the independence of the judiciary. So that's why it's a pillar of the Constitution that the judges are independent and they are able to operate independently of the government of the day.
But suppose then Parliament determined it wanted to vet judges.
Right. Well, if it did, then that would change. Parliament could do that. Does one have to have political connections to get a judicial appointment? Not at all. It's done, I would hope, purely on ability and merit. There is an independent Judicial Appointments Commission, which is chaired by a non-lawyer. It has a preponderance of other professionals on it that are not lawyers. It has lawyers on it too. And they operate a careful system of selection, which is done through first of all by written application, and then sifting, and then by interviews and by assessment. And that is transparent in the sense that anybody can look at what has gone on, and the appointments are then made by the Commission and not by the government and not by the judiciary, but by this independent judicial commission.
So I think we've sketched out some of the differences between our constitutional system. What strikes you as odd or problematic about the United States constitutional system? And I think you're free to criticize us without being retaliated against by the audience.
Well, I wouldn't want to offend my host, but I think it's almost a natural product of the way in which your country has developed, in splitting off from the Brits in the first place, in trying to avoid what they saw as the pitfalls of what had gone on in England prior to that, to guarantee the various freedoms in a clear way which is there. And I think it suits the way your country has grown and developed. As has evolved in a different way, incrementally really, where the Constitution really doesn't play anything like the same importance, in the sense we're sort of not happy with what we've got, but we're less fearful of what might happen if we didn't have one.
Well, that was actually a thought that was going through my mind as you were discussing this. I think in the United States, if you said we're going to do away with judicial review, that Congress could enact laws that change the Constitution or that would allow people to be put away for 3 months without any review, or that would suppress freedom of speech, the average citizen in the United States would be fearful that the government would abuse that power and enact laws that were oppressive. Is there no such fear in the UK?
I don't think so. I think one of the other aspects, which is perhaps not as obvious at first sight, is things are more centralized in the UK, in the sense that we have national papers, sort of national television, and the commentators very quickly would pick up on something like that, and there would immediately be a real concern that there is something wrong, and the members of Parliament would be spoken to by their constituents. It would be, I think, a lot easier to galvanise opinion if there was some fundamental change like that. I think it's a function of our society that there's instant news, instant comment on virtually everything now, which there wasn't 20 years ago or 50 years ago. In some cases it's a good thing, in other cases it's not such a good thing. As a by-the-by, I think one of the things that I would like to see is no comment on anything that's happened anywhere for 24 hours, just to allow it all to settle down, rather than just people coming up with something uninformed for the purposes of saying something. And I think these sort of we would say off the cuff remarks, but snap reaction things sometimes do far more harm than good. But
I would agree with you on that one. There's a strain of at least academic commentary in the United States that suggests that both Congress and the people may be less attentive to the Constitution and its principles because they rely on the courts, and particularly the Supreme Court, to enforce the Constitution. You even sometimes see in the United States, when there's debates over the constitutionality of legislation, you sometimes see legislators say, well, the courts will sort that out. Do you think it's possible that the attention to the background wallpaper of constitutional principle that the commentators, news people, academics, people generally pay is in part a product of the fact that you don't have courts that have been given the responsibility for the Constitution?
Oh, it could be. I hadn't thought about it quite in that way, but it could well be. But the problem is that the government may have political views from a particular point of view which it wants to proceed with, but they are entitled to do it. But as governments fall out of favour because the constituents or the country is less and less enamoured by what they're doing, or there are failures in the policies, a financial policy or whatever it happens to be, then the legislators have to be quite careful what new laws they come up with, because that could get them into even more trouble. So there's a temptation then to come up with some sort of law which may find favour. But I think it's really more events generate the problems, rather than somebody sitting down and having a policy of changing the laws. And it's outside events, such as all these economic problems that we've all suffered from, that has completely thrown any sort of sensible plan which our government, and indeed any European or American government, had, because of having to cope with billions of dollars and billions of pounds being pumped into this system. The end pragmatic result of that is all our budgets in every area have been cut down dramatically, whether it's education, health, social services, the law, to the detriment of us all. And no legislation can actually change that. That is outside forces which they've got no control over.
Let me just close up by one final question, and then I think we'll throw it open to the audience. Hopefully we can bring some more people into the conversation. At dinner we were discussing the significance of legislation arising from Europe and its increasing importance for the UK. At least from my understanding, from the perspective of the European Union, the laws of the European Union are superior to the laws of England.
Yes, that's the theory.
How is that theory, which includes I suppose not only the EU but also the Convention on Human Rights and so on.
We have adopted the European Convention on Human Rights.
So does that change the role of the judiciary in relation to acts of Parliament?
No, I don't think it does. I mean, that if we have adopted, which we've had to have done, a number of pieces of European legislation, they are interpreted in the same way as we would interpret any other act which has been passed by Parliament.
So do the courts apply European law directly, or only by virtue of enactment through parliamentary acts?
Only really by virtue of it being brought in through a parliamentary process. But there are very few laws as such. There are more directives on things like health and safety is a very good example. We have a proliferation now of directives on health and safety, which the average citizen gets very upset by, on the basis that they think they can handle ladders and things perfectly well without having to have 3 people holding the end of the ladder, or, you know, whatever it happens to be.
It sounded, when you were saying these things, it sounds just like the way people talk about the federal government in the United States and the Occupational Safety and Health Commission and their regulations.
But I mean, can I ask you one thing? Something that has caused us a lot of concern recently is a thing called the Freedom of Information Act. I don't know whether you have a Freedom of Information Act.
We do, commonly referred to as FOIA, because we like acronyms.
But that has allowed citizens to ask all sorts of questions of government, which were not able to do before. I mean, one commentator has been a number of commentators have been very concerned about this, because it has allowed or jammed up governmental time in trying to answer all these difficult, complicated questions which may or may not be relevant, but it has allowed single issue groups to focus in on things and saying, why has the government done this and why has the government done that? One example that some of you may have recalled if you've followed the news, we've had quite a lot of problems with our members of Parliament's expenses and whether or not they could have their moats cleaned out and sort of things like that. But that was all out of a Freedom of Information Act requests of somebody who thought our members of Parliament were paid too much. As a matter of fact, I don't think they are. They're paid equivalent to about $80,000 a year, which isn't really a huge amount. And they get expenses for their staff on top of that. And there was this sort of extra $30,000 sort of amount floating around there, and they were told, well, if you just put in a few bills for a few things, you should be entitled to much of that. And it was an accepted thing that was done. It wasn't actually right. So this is where these bills for duck houses and cleaning out moats and all that sort of thing suddenly appeared from. But it's really made the government a laughingstock, because most of the MPs do a very good job, and it was just treated as a sort of bit of extra money. It's not a huge amount, which they thought really they were entitled to. They weren't, and it was wrong for them to have done it. But this freedom of information can make, I think, life very difficult in some areas. I mean, all governments require some secrecy, but they mustn't have too much. If there's too much, government would rot, really, from the inside. But there must be some ways of seeing what they're doing, but they must also be able to operate without being too concerned about every single issue group out there for the greatest good of the greatest number. And I see personally this Freedom of Information Act as not the greatest blessing that has ever been there.
Well, we've had the Freedom of Information Act since the 1960s, if I remember correctly, late 1960s. We also have something called the Government in the Sunshine Act, which is closely related to the Freedom of Information Act. I guess I would say our Freedom of Information Act has caused significant problems. It tends more to be the time-consuming nature of responding to record requests. There are numerous exceptions built into our Freedom of Information Act that allow the agency that is the custodian of the records to withhold records that pertain to criminal prosecutions, that are investigations that are ongoing, or that involve confidential business information. Personnel records would be among them. And there's a lot of litigation over whether agencies have properly withheld information or not. And I think We've had more problems with that. I guess we're a litigious society, so it always boils down to the litigation over it. I think we've had more difficulty with that than we have with information that ought in good conscience to remain private or secret being disclosed and leading to problems in that way. I could be wrong. Other people might. Judge, do you have a lot of Freedom of Information Act cases?
No, but I think you've quite accurately characterized.
Okay. Did I answer your question?
Thank you.
Well, I think we'll open it to the audience if there are any questions, assuming that we have people who are intelligent, what did you say, educated. And slightly drunk. When we have a question, we'll have the students come and speak into the mic, and I'll remind you that no filibustering. We have a judge. Judges cut off oral argument.
I promise no filibustering. My question is a concern of some of us for about a decade now, where the Supreme Court of the United States overrode a tradition of a long time, its own Constitution, that clearly spelled out the procedures for deciding who the president is when there's a dispute. And in other words, Florida should have been allowed to settle that dispute and then send their man to Congress, and then it could have been settled according to the law in the House of Representatives. That's clearly spelled out. What do you do when and maybe there's a precedent in Britain, so I'm asking both of you, what do you do when a Supreme Court or whoever acts as it in Britain just walks all over its own Constitution and decides to take things into its place? And how could we remedy that now in our present Constitution? In other words, we've got a Constitution. It already clearly spells out how to do this, and they just ignored it. So we can't just pass another similar law. Thank you. I'd love to hear both of you sort of act as your own Supreme Court for us.
Well, I think most of you know he's referring to the Bush versus Gore decision from the year 2000. I often refer to Bush versus Gore when I teach constitutional law, but for a slightly different point, which is that at the time Bush versus Gore was decided, Al Gore was the sitting vice president, and by virtue of that position, second in command of the most powerful military in the world. And when the Supreme Court made its decision, he went on television and said, "The Supreme Court has spoken. We must abide by the Supreme Court decision," and he acceded. I've always thought that was pretty remarkable because I don't think the 5 votes were by 5 particularly powerful physical specimens who would have been capable of overcoming the army on their own. And so I think it's a striking testament to the rule of law and the role of courts in the United States that at that juncture, the decision in Bush versus Gore would be accepted. And I bring that out now because I guess the question is, which is the worst type of error that you risk in a constitutional democracy? One error that you have if you give courts power is that courts are comprised of people. People don't always behave correctly, and they are in a position to do considerable mischief through their decisions. They can approve the internment of citizens of Japanese ancestry who have done nothing wrong. They can declare African Americans not to be citizens of any state and therefore unable to claim any kind of judicial protection. So those kinds of errors are built into a system where you have courts that have the authority to determine what the Constitution means. The question is, if you decide we're not going to accept that, we're going to do something, then what you have to do is you have to take political retaliation against the courts. You think in terms of during the early founding period in the United States, Justice Chase on the Supreme Court was impeached because he made a decision that was unpopular. I personally, and I go back and forth on this sometimes, but in the long run, I personally think we're better off with a court that is capable of deciding what the Constitution means and a system that respects that decision than with the alternative, which is a system in which the courts are politically subservient. Now, maybe if we could go to the British system, we'd have both, an independent court and one that lacks the power to declare who's president of the United States. But in our system, I think the choice is either we have a court that has meaningful authority to interpret the Constitution, or the courts cannot serve as a bulwark against unconstitutional action. I don't think you can have it both ways.
Well, I'm an outsider looking in on this. I mean, it's an extraordinary position to see that whatever the machine not working or whatever the physical aspect was,
the hanging
chads meant that could have affected who became president. And it does seem to me an extraordinary thing that decision was taken in the end by judges as to whether it was a valid election or whether it wasn't. And I think the basis of your question is that the rules were broken somehow, and there was no way in which it could be overturned. I'm not sure how it could have been overturned without having a completely new...
Well, there is a constitutional procedure for dealing with contested elections in which the state has the authority to determine, and then if there's a dispute over the electors who are sent, whether they're valid or not, then it's determined by the House of Representatives. So I think the question was, the Constitution gives a process for resolving this kind of dispute, and the Supreme Court ignored it.
And wasn't really followed. But the trouble is there is a political agenda underneath this as well, but because the governor of the state was related and all that sort of thing. So there are quite a lot of strands.
And the person that ran the election process is a political official in most of the states in the United States, which has always struck me as problematic. So
we have very strict rules indeed on vote counting and procedure. And I mean, there are problems, but people are human and fallible, and we have had some problems. For example, with heads of households in say Indian families, who apparently would vote for the entire family, and there would be sort of 48 votes come in in one block and that sort of thing, which is contrary to the rules and regulations. But it seemed to me, again looking from the outside on your particular example, that had such a fundamental effect on what happened subsequently that how on earth that could be dealt with. I mean, one of the great what-ifs is had Gore been elected, would we be where we were today? I mean, it's an extraordinary concept. I'm not talking as a lawyer, I'm just talking about this as somebody who just observes, and it may just have turned.
Tony Blair might still be Prime Minister.
Yes, well, true. But I really don't know how you would have dealt, or we would have dealt with a problem like that, where the rules on the face of it were not followed, but they should have been.
We have another question from the audience.
You talked about the Constitution or non-written Constitution of the United Kingdom, but the United Kingdom has different elements, like Scotland versus England. Are there any differences in this non-written Constitution?
We've had a system for some time of devolvement. The Blair government thought it was appropriate that there should be more self-government for Scotland on the one hand and Wales on the other. Strangely, we evolved two separate systems. and the Scots have a greater ability to self-govern than the Welsh have. In the end, it's all down to money. It's who actually controls the budget that's important. And the Scots have slightly more control over the budget than the Welsh Assembly actually have. And I'm afraid it's ended up in Wales as more of a talking shop and not very much actually being done. But I don't know. I mean, speaking as a citizen and not as a lawyer, I would far prefer us to be united than disunited, and I don't think it served the Scots very much good to be separate. We are, well, they would say, well, we should have access to the oil which is out there off Aberdeen, and we should run our own society. But in reality, given their population, they would have real difficulty. And the head leader of the Scottish Nationalist Party, his main rhetoric was, we can be a Celtic tiger or Celtic tiger, rather like Ireland. Ireland did rather well out of the European community and got quite a lot of grants and had quite a lot of infrastructure and attracted quite a lot of industry. But sadly, that's now all gone. And companies like Dole, for example, had a huge manufacturing base in Ireland, and they didn't feel they were getting enough money from the Irish government, and Dell have gone somewhere like Hungary. It's either Hungary or Poland, where they got a far better deal and cheaper labour, which shows the transitory nature if you're not careful. And the Irish bubble has burst, and I suspect Scotland would be in exactly the same economic position with not having enough internal industry to generate wealth. So on the political question, it's always, I think, easy if you're a minority to actually complain, but I think very often you're better off together than you are apart. And I think most Brits, well, most of the English would say we're all better off together, but the average Scotsman still would like to fly the Scottish flag and do a bit of sort of Rob Roy stuff. But I mean, the reality is it's always very difficult for smaller states and smaller communities to exist in this cutthroat economic world. And on the constitutional side, they do have powers within their budget to rearrange things. And one example of that is university students get a higher grant in Scotland than they do in England, and that's just a way of using their budget in a way that we don't in the same way in England. But they have far fewer students and a far smaller population, so it's something they are able to do.
Are the courts separate in Scotland
Yeah.
and Wales also?
Yeah, they're not in Wales. Scotland has an entirely different system based on the French civil system, and we, the English, know very little actually about how they operate in Scotland, even though it's only 400 miles away. And I don't know whether we're going to get on to Lockerbie or not, but they are entirely able to decide what they want to do, independent of the government in London. And if they decide that they've got this compassionate rule, which they are able to use to free somebody if they wish, and that's what they decided to do in relation to the Libyan prisoner, which was released just the other week, regardless of the political consequences. I've no doubt, I have been asked several times, what are my views on this? And in my view, I think the British government actually did not behave particularly well on this. I don't think enough regard was paid to the American families who lost families in that Lockerbie disaster. But in the end, it was a decision made by the Scottish Parliament, who had sovereign power in relation to that act. That's what they decided to do as a compassionate act. Whether in the long term there will be any commercial advantage, I don't know. But the Scots would say, well, we don't care about the English. It's not going to benefit us much if London have trade deals with Libya. But another strand in this rather difficult question is, it is a good thing probably in the longer term to encourage societies that have been terrorist orientated to bring them back into the mainstream by having better relations with them than by continually kicking against them and not having any contact with them. I certainly believe in the more you talk, the more you understand, and the more progress we can make in the West against what is a real problem. which is not necessarily in Libya, but it's certainly in other parts of the Middle East.
I have kind of a technical question in a way, but I think it has broader appeal in this sense. Yeah. I think most Americans are familiar from watching TV shows about certain aspects of criminal procedural law that in our country flow from the Constitution.
Yep.
Such things as illegal searches and seizures,
yep,
or the right to remain silent, these kinds of things. You're a criminal judge, or a judge who presides over criminal cases. I'll keep quiet about all those things.
I understand what you're saying.
Yeah. But do you, in your practice then, deal with challenges to the admissibility of evidence based on concepts such as unreasonable searches and seizures or rights to remain silent? And if so, where do those rights to the public come from?
Well, they are actually enacted in an act passed by Parliament. And they are there and they are clear. The judge will have some discretion on some searches if there's been an error, a slight error in the way it's done as to whether to admit it or not. And sometimes I will rule it in, sometimes I will rule it out. I'm afraid in the end I've got to make a decision. But the basic rights, all those basic rights, are in one act or another. Unfortunately, we have a huge number of acts of Parliament, particularly in criminal law, which have been passed by successive Home Secretaries. They're the ones who are responsible for the criminal justice system. Really almost as signs of their own importance, and new broom coming in, therefore a new Criminal Justice Act. And there is a statistic that there have been more laws passed since Tony Blair came into the Labour government, came in 1997. More laws passed since then than in the whole of the preceding 300 years, which just gives an example of the problems we have to deal with. And unfortunately, many of them don't interrelate properly. They haven't been thought through. And it's very difficult for the judge to weave his way through the various statutes that are actually there. But the basic rights are clear and obvious, and I would hope we would pursue those almost regardless of the actual statute, but the fundamental rights of the right to silence. We do, as an interesting twist on that, although there is a right of silence, the government brought in a newish act, I suppose 5 or 6 years ago, which is called an adverse inference. So although you have a right to silence, if in fact you then use in your trial 6 months later a story which on the face of it is quite credible, which you suddenly produce as your defence, which you had said nothing about when you were arrested under your right to silence, the judge can direct the jury that there can be an adverse inference taken against you because you should have been able to say, this was my defence when you were arrested at the time. Now that is contrary to the right to silence, but yet the government have thought it appropriate to be able to, and it's common sense I suppose in some ways, in that if you've got a complete answer, why didn't you say so when you were first arrested?
Because you've been watching a lot of American TV, and you know that the best thing to do is not to say anything,
exactly.
Even if you have a perfect explanation.
That's
for
right.
it.
So there is this keep your powder dry approach, but you run the risk of this adverse inference, the judge directing the jury, that you may take that into account in support of the prosecution case. So that's a way in which things have changed somewhat, and so there's the Act of Parliament which says these adverse inferences can be used.
We need a mic.
Question.
Sorry, I think you need the mic so that...
Thank you. In the United States, historically, minority groups were often not able to rely on the political process here. They were outvoted, kind of a tyranny of the majority. And so their last course of redress was the courts, and was to find certain legislative acts unconstitutional, or even the status quo unconstitutional. And I'm wondering where groups like that would be able to turn to in a country such as the UK?
Well, it depends what they're complaining about, because we have freedom of assembly, freedom of speech, freedom of religion.
If, not that it would happen now, but for example, when we had segregation in our schools,
Yeah.
it may have been extremely unpopular in our Congress to overturn that at the time.
Yes.
The political cost may have been too high, so we were able to have our Supreme Court decide that that was against our Constitution and against certain fundamental rights. And so I'm just wondering if there were something analogous to that, where there was a group who was always outvoted, what process they could turn to.
I think in the end it's galvanizing public opinion.
Okay.
I think that's probably the only way of doing that, and of having newspaper columnists and people on TV and radio, then in order to influence the legislators, who would then pass, hopefully, a law which would allow whatever it is that they felt unfortunate about or unhappy about.
How has that worked for minority groups like Islamic people in the UK or people of African descent?
Well, again, it depends what they are actually complaining about. I mean, looking at the obvious example of our radical Islamic young men, they are in fact operating in a completely free society. If they were operating like that in Iraq or Iran or Syria, they'd be shot, or they'd disappear. I mean, when you think of Iran 3 weeks ago, 6 weeks ago, and they had the Green Revolution, an awful lot of those people on the streets who were complaining about an election which apparently had been stolen from them, where are they now? And apparently an awful lot of them have disappeared, and disappeared for good. But in a free country, that just simply wouldn't happen. It wouldn't happen here, and it wouldn't happen in the UK, and I hope it wouldn't happen in most of Western Europe. But if you're operating a system there where there is no rule of law, what the government says goes, that's a real problem. But I think one of the problem is not a problem, because the difficulty with our radicalized young men is that they're operating in a free country. And that's one of the attractions of many coming to the UK in the first place, is that they can say what they like, and they're allowed to say what they like, providing it doesn't go beyond the pale. I mean, I tried a case 18 months ago, 2 years ago, where there were a group of protesters on the streets after the republication of the cartoons in Denmark of the Prophet Muhammad, which is a great slur on Muslims. But this group, who were real radicals, suddenly were producing enormous posters which were saying, behead anybody who defies Islam, and bomb the USA and bomb the UK. And that that's beyond the pale. I mean, that is, and that's breaching a number of our laws. They only arrested about 3 or 4 of the ringleaders, because the ringleaders at the end of this march outside the Danish embassy, where they set fire to the Danish flag, and indeed tried to set fire to an American flag as a matter of interest, but they didn't have many of those, but they certainly had a Danish flag outside the Danish embassy. But they were addressing, the ringleaders were addressing the crowd, saying, the streets should run with blood with those who disagree with fundamentalist Islam. And you guys out there that we're addressing, the believers, should be in Iraq and Afghanistan, certainly Iraq and Afghanistan, fighting and beheading American troops and British troops. And as a result of that they were arrested, in fact charged, under soliciting to murder, to encourage others to actually go out there and kill. And the jury heard all that and convicted in fact 4 of these young men, who I subsequently sentenced to a certain amount of incarceration. But they were, I mean, I'm afraid they're so out there, they were so fundamentalist, that they didn't care really what the courts did, because they believe in something we can't comprehend. I mean, 99.99% recurring of Muslims are good, hard-working people following the Quran, but you get this just very tiny number who are Al-Qaeda, really. They're out there somewhere, who believe in caliphate state where the rest of us have no standing. It's something that anyway, that's one of my own experiences, but And if I can just pick up on that, I mean, I like what Adlai Stevenson said at one time, which I think is the sign really of a free society, is where it is safe to be unpopular, where that you can say things that are unpopular and you're not going to be shot or killed or whatever. And that's the sign, I think, of a true democracy. The other sign of a true democracy is whether the leader, when they're diselected, where they actually go, whether they go out the back door. And in many countries, particularly in Africa, they just won't go. And Iran, again, is an example of that. But at least, number 10 Downing Street, as the new Prime Minister's come in the front, the old one's going out the back, and it's the same in the White House, isn't it?
Well, that goes back to the Al Gore speech that we were just talking about. Yeah. Are there other questions?
That's loud. I'm uneducated, I'm dumb, and I'm sober as a bird, to your dismay. Just one question. How has Oliver Cromwell's experiment affected Parliament?
Okay. Well, I mean, it's got to be set in the historical context. The Royalists were an elitist lot who did, very well, and the poor, the Roundheads. This was really a rising of those who felt disenfranchised and not doing very well under the then system. But I mean, it's difficult to put ourselves back into that historical concept when there was a far more feudal society, a far more structured society, and it's very difficult to break out of that. And one of the few ways you could break out of it was either being a soldier, or in fact by being a monk, or being a sort of cleric and working your way up that way, a sort of a Sir Thomas More type of thing, if you could work your way into the establishment that way. But he had considerable support because he was a Republican and saying, the king and the royalists are keeping it all for themselves, and the country then rose up. But he abused it in the end, unfortunately, and lost the plot. And it sort of turned against him, and that experiment, which only lasted about 20 years, failed dismally, to the extent they brought back in a king who had nothing much going for him, apart from the fact that he was the son of Charles I and was actually in Scotland at the time. He was a Scottish king, and they brought him down, and he carried on. But it did sow the seeds of rights of the individual. And hence, in due course, the rule of law became paramount, and the king's powers were very much curtailed. So that now the monarch is a figurehead; it's a symbol, and the crown has no power, real power at all, apart from has a sort of reverence and provides this stability, which we quite like. I mean, you may not, because of your the way in which you've grown up in the society you've grown up, but it does. The interesting thing is what will happen when the Queen dies, and who then might become head of the monarch after that, whether it will be Prince Charles or one of Prince Harry or one of the other two sons. But we'll face that when we come to it. But they are selfless people. They don't have magical qualities like kings used to, the French kings and the monarchs used to anoint themselves with. But what they are hard-working figureheads who turn up, do things, and it just is a bonding, sort of cementing aspect to our particular way of life, and it seems to work reasonably well for us. Meandering off the question a bit, I'm sorry.
This will be our last question.
Well, I was curious. Constitutionalism in the USA is bound by the reverence for the actual words of the Constitution.
Yes.
And I was, in my own understanding, trying to reconcile how adaptable the Constitution is to each case that it's applied to, versus, where in Great Britain, judges are required to renounce all political affiliations. That doesn't happen in the U.S. I mean, they're heavily screened, but I was trying to grasp an understanding of what those factors might be, whether it's just the political climate at that time, or if it really just depends on the judge's whims.
You're speaking in terms of U.S. constitutional interpretation. Well, I think it's important to understand that one of the reasons why the Constitution has lasted as long as it has is that it's very vague. There's a number of specific provisions in there that say things that aren't so vague, like the president has to be 35 years old. That's pretty clear. But what due process of law means, what commerce among the states means, what freedom of speech means, those are phrases that don't have a fixed content. So that when a court is attempting to apply them in a real specific case, like whether holding signs that say death to Americans is a violation of free, or can be prosecuted without violating freedom of speech, the court's really starting with the text, but it's looking to the principles and values that underlie the text and trying to give meaning to that in the context of a particular case. Because of that, it's impossible to separate the judge's values from the values of the Constitution. The judge sees in the Constitution his or her values a lot. It's not really possible to separate them. So what you find, I think, is not a self-conscious choice by judges. I'm going to pursue my political philosophy at the expense of the words of the Constitution. But instead what you find is the judge searching for meaning in the underlying principles of the Constitution sees mirrored in the Constitution the values that he or she brings to the position of being a judge. That's in human nature and unavoidable. And in the end, I think it's really not such a bad thing. There have to be enough judges that agree on the values in order for the outcome to constitute a majority. And it's that flexibility that allows the Constitution to evolve over time and adapt to new situations. And I think that's what a Constitution needs to be able to do. But that's just my opinion.
Well, I defer to the professor. I agree. I think that the shorter the document is, the better. New states, if a new state is created, have enormous trouble actually drafting a constitution. They feel they ought to have one. But trying to draft one which covers the eventualities that they feel are necessary is enormously difficult. And the longer it is...
How long was the EU constitutional draft? Hundreds of pages?
Hundreds of pages. And it's hopeless. I mean, nobody takes the, it's hopeless. Because you try and cover every eventuality, and inevitably, the first thing you find, it is not covered in this draft you've just produced, and they spend years fiddling about with it. Whereas the simpler it is, the better it is, because it does then allow flexibility. But you are always rely on the ability of those who interpret it. And that's why you must have the best possible people as Supreme Court judges, really.
Well, thank you very much, Brian. I've sure enjoyed having this conversation.
We thank you very much.